Ace Magashule argues that the party's National Executive Committee does not possess the necessary legal powers, to change a resolution of conference. So is it correct to assume or opine that the NEC, as the highest decision-making body between conferences, has the legal standing to make and amend decisions?
So what is in dispute here is whether or not the NEC actually did amend those decisions. And the court found that far from having amended them, the NEC simply implemented the decisions of the National Conference of 2017. Now, if Mr. Magashule or those who support him wish to challenge this, they must first do so inside the party and decide that internal to the ANC, there was some kind of violation of the rules. The court decision certainly would back up the party's view that no such decision was made, and that there wasn't a change in either the rules and or processes adopted by the National Conference, and that the details were actually just the implementation of those rules. So now it's a matter of interpretation between whether or not people agree that the rules adopted fulfilled the mandate adopted by the National Conference, or whether they in fact changed it. And if one looks at those, it is very hard to see a rational justification for assuming that the specific processes adopted by the NEC and that were implemented by the NWC were necessarily in violation of the larger principles that had become an issue for the party and therefore became part of its agenda adopted at 2017.
Is he making a bona fide argument, though, when he questions the constitutionality of the step-aside resolution, when he should have contested it when it was adopted in the first place back in 2017, given the kind of power and the level of influence that he wields?
So this is also precisely where the court pronounced and said that if you were present at the meeting, if you had opportunity to participate in the process, you can't at the end of the process, when you are subjected to that process, then object to the process having been implemented. And earlier this week we had, for the last 6 months, a similar case with a different member of the African National Congress, with Jacob Zuma, who implemented the State Capture Commission and then objected to its operations for rules that he had implemented as head of state. And so this is something that ordinary people who work in corporations or for companies know on an everyday basis. When you sign your contract, you sign up to a certain set of rules that you will abide by, including the rules around discipline. And then you cannot object when the disciplinary process happens to the particular rules. You may object to the justice of the application and the ways in which the corporation and HR officials operate in that meeting and violate the rules that they have also agreed to abide by. But you can't agree to abide by rules and then after they become applicable to you, start questioning their legality. That's very disingenuous, as every employee in South Africa will have been told had they tried this route. And as members of voluntary associations, whether they're churches or stokvels, also know intimately well, you can't say, I'm going to play by the rules, and when the rules are used against you, suggest that the rules are unfair, because that means when they're applied to everybody else, you're in support of them.
Now, for purposes of analyzing whether Ace Magashule was treated fairly, I think let's rather focus on the role of Jesse Duarte, his Deputy Secretary General, to issue a suspension letter. Well, we've just heard the court upholding her powers to issue such a suspension letter. So to what extent does this declaration embolden Jesse Duarte?
I don't think it emboldens her as an individual. What it does allow the African National Congress to claim is that its processes actually stand up to the test of legal scrutiny. So very many people will have had the kind of idea that political parties often ignore the rules that are applied outside of political parties in matters of law and tend to focus very much on what's expedient inside the party. The way in which rules in parties are set up is often to maintain the strength of the organization. We saw this with the African National Congress's relationship with Dr. Makosi Khoza and how it was a deeply problematical ethical issue for the country, but it was an entirely legal issue. And the Constitutional Court reminding South Africans in a different judgment that political parties, given the nature of the political system and given their internal dynamics, do have the right to remove people who do not abide by the mandate because of the nature in which they have to appeal to the electorate. But that does mean that people can't always behave according to their conscience. So the call for electoral reform by allowing independent candidates to stand at national and provincial elections means that the power of political parties to do that, to implement their vision over the individual conscience of individual members, or the individual acts of individual members or desires that such members may have, will mean that more and more people will be able to either stand as independent candidates or vote for independent candidates. And this will presumably change the power of, one, political parties, and two, the power of individuals who want to participate in political processes, so that they do not have to simply become members of powerful political parties where they have to be subsumed by rules that they may not always agree to.
Okay, great chatting to you, Angelo. Thank you so much for your analysis and for your reflections on this story. And I suppose then that this is not only an ANC case, but it does show to the greater South African public that the courts do exist, and it underscores the importance of upholding the rule of law to solve disputes. Thank you so much for your time. That was analyst Angelo Fick joining us via Zoom.